Well, hello. Good afternoon, everyone. My name is Brian Lawrence, and I am the CEO of the Seattle Public Library Foundation. And in behalf of our partners in this webinar series, our friends at the King County Library System Foundation, I want to welcome you all to today's event. This year marks our fifth year of hosting these free estate planning webinars. And all of these webinars have been recorded over the years, and you can access those recordings on the Foundation's YouTube page. And we will go ahead and put that in the chat. So you'll have 5 happy years of recordings to look over if today's webinar inspires you to even learn more. A colleague at an arts organization recently asked me why the Seattle and King County libraries continue to host these free webinars, since quite frankly, some of this information you're usually charged for by an attorney. And it comes back to our mission to support and enhance the library's ability to serve our community. And when we think about our mission, we think about providing trusted educational resources like this webinar so that each of you can make informed decisions about your future and planning your legacy. And, frankly, we know that estate planning is incredibly overwhelming. It's a fact that about 70% of Americans out there do not have a valid or updated will. And for me personally, that keyword there is updated. I pulled mine out of the drawer recently and saw that my last update was in 2011. So my situation is very different now, and I've taken steps to put in place to plan and update my own. But it just goes to show that you're not alone if you are thinking about planning your will. Anytime you're talking about planning end of life decisions, it's kind of hard, but it's important. And I think you'll find that you will receive tremendous satisfaction and a deep sense of relief once you've taken care of matters and have everything signed off and completed. So we hope that these webinars will make this a little less scary for you, and I hope they will help you, educate you, and then motivate you to connect with a professional to start or update your plan. And if you consider including your library as part of your plans, we obviously would be honored, and we are available to support you. I know I can speak for my organization that whenever we talk to a potential supporter about estate planning, it's simply a way for us to provide information, to share with you what your library impact could be, and to honor your wishes fully. So we'd like to make sure that all of our supporters see themselves as potential estate donors in the future. And just as many of you already support our organizations through your generous annual gifts for many, many years. So it can be simple and easy and impactful. So with that, I'm going to turn it over to our amazing speaker today. We are deeply honored to have Mitch Corey with us. Mitch is an estate planning attorney with Stokes Lawrence, where he guides clients through the complexities of trusts, probate, and wealth transfers. So we're grateful to have Mitch for sharing his knowledge with us. And I also want to say a couple kind of housekeeping tips. So again, we're recording this session, so you're going to receive a link to Mitch's talk and the slides after we wrap up. So feel free to take notes, but also know that we're going to send you those slides as well, so you can pay full attention to Mitch. And then to ask a question at any point, please go ahead and use the Q&A button. There's kind of two buttons down there. One's the Q&A and the one's the chat. So we ask you to use the Q&A button. And Jessica Carso from King County, she's going to be looking at that Q&A button and feeding some questions to Mitch. And every time you sort of upvote that or give the little thumbs up sign, it'll kind of boost those questions up so Mitch knows what so many of you might be interested in having answered, and we can upvote it. And then finally, when you sign off today, you're going to be prompted to take a short survey about your experience. So if you have to leave a little early, we ask that you just take a few minutes to complete that survey, which will help us and help us plan for future events. So Mitch, welcome to our webinar presented jointly by King County and Seattle's Public Libraries. And we'll let you go ahead and take it away.
Well, thanks, Brian. Let me share my screen here so we can see my PowerPoint presentation. And so I believe that's sharing. So everyone can see the 10 things to know about estate planning in Washington State. Again, thank you, Brian, and thank you, King County Public Libraries for letting me do this. My name is Mitch, and the first slide is the best picture of me ever taken. There it is. I'm a trust and estates attorney at Stokes Lawrence. Trust and estates is the department here. We have a number of attorneys and paralegals and legal assistants that are all working on trusts and estates. What does that mean? That means that we do estate planning where we are talking to people about what they want to have happen in the event that they are either incapacitated or after their death. And then we also do the other end, which is the administration, where after someone has passed away or if they are incapacitated, we address what's going to happen next. And then I guess the trust and estates aspect is the estate is your stuff after you pass away. And a trust can be something you set up during your life. It can also be set up after you pass away to manage your assets. With any estate planning, there's a wall of words. And as a note, I don't think the slides were presented beforehand, but I will save these all as a PDF document that can be provided to anyone viewing this afterwards. So you can go back and read through this. But just some common definitions to go through as we start here. When we're talking about estate planning, most people are very focused on the will, the last will and testament. That's your legal document, your writing that describes what you want to have happen to your stuff when you pass away and who's in charge of that. A trust is an agreement where one party, who is the trustor, the grantor, it's also called the donor, transfers assets to another party, who's the trustee, who's entrusted to hold and manage those things for the benefit of a beneficiary. And now a trust can be a separate agreement. A trust can also be included in your will, such that after you pass away, your will creates a trust or says this property will go to a trust for the benefit of my spouse, and this is the trustee. The terms of that trust are then inside the will. The next word is probate. This word means a lot of things, but kind of the most pared down definition is that probate is the court process where after someone has passed away, that individual's will is presented to the court, and the court with jurisdiction confirms that that is in fact the last will of the person that passed away. And the person named in the will as the personal representative is authorized to carry out the terms of that will. There's other statutory requirements, and probate is different for each state. And we're only talking about the probate process in Washington. Now, I mentioned this before. In your will appoint who your personal representative is. Personal representative is a synonym with executor. It's just another word that means the same thing. Throughout the Washington statutes, they use the term personal representative. The personal representative is appointed in your will to carry out what it says, to carry out the distribution of your property, and to manage your estate during that process, which could include probably your final income tax return and possibly estate taxes. A trustee is another fiduciary, and the trustee is the person in charge of the trust. Again, that could be something you create during your life. It could also be something you create in your will. Your personal representative and trustee, those can be different people. Those can be the same people. The other person, another fiduciary, is your agent. Under a power of attorney, you have an agent. The power of attorney is when you, the principal, signs a document to manage your affairs for your agent to manage your affairs, subject to the terms of that document. The last kind of fiduciary we're going to talk about is a guardian or conservator. This is a fiduciary appointed by the court to manage an incapacitated person's decisions. That's a guardian. Or to manage their stuff. That's a conservator. A conservator or guardian is appointed through a court process for a minor or an otherwise incapacitated person. And throughout this, I mentioned the word fiduciary. What does that mean? Fiduciary is the term when someone is entrusted to manage the assets, or in some cases, the decisions on behalf of another person. And they are subject to statutes and responsibilities because of that. So I guess beginning with our list of the 10 things everyone in Washington needs to know about. One thing is, what is an estate plan? What are your important estate plan documents? Um, I'm gonna ask support. I see a question that I see a black screen. Is my presentation on the screen?
Yes, you're just fine.
Oh, okay. Thank you, Jessica.
Absolutely.
The important estate planning documents, when we're talking about your estate planning, we're talking about both what's happening in the event that you are incapacitated, which means that you can no longer make decisions for yourself, either probably because of like a health issue, or maybe you aren't in the country. That is addressed through what are called powers of attorney. The powers of attorney are documents that you would sign that would appoint your agent to act on your behalf, subject to those powers of attorney. Oftentimes, you would have two separate documents. There would be the general and financial agent, and then there would be the healthcare agent. And those would be under two separate documents, which means that you would have, it could be the same person, or you could have different people. One would be managing your stuff, your finances, and one would be managing healthcare decisions and talking to your doctors. This is probably one of the more important estate planning documents immediately, because this is what happens usually in kind of an emergency situation. We think like a car accident or a health crisis, in who is going to be paying bills, who is going to be talking to doctors. This is an important document if you had your estate planning done a while ago, to look at and see what that says. Another aspect of your estate planning document is your healthcare directive. This is a document that provides your wishes for end-of-life care. It provides whether you want to be provided with artificial hydration or nutrition if you are in a coma or otherwise have a terminal condition. This document is important from a healthcare perspective in terms of giving guidance to medical professionals for what your wishes are. It's also important for your family or the people that are close to you, who may actually be the person interfacing with the hospital making those decisions, because they are going to want to know that you had thought about this and this is what you wanted. As a side note, if you are thinking about this, talking about this with family members is another good way, because usually when these decisions are being made, it's at a moment of pretty extreme stress, and being able to rely on having that discussion with you or having a healthcare directive where it's written down can be really relieving for a family. Another document is your disposition directive. This is a document that says what you want to have happen with your earthly remains when you pass away, whether you want to be cremated, buried, or composted. It also says who is going to kind of be responsible for doing that. The last document, and probably the most classic of the estate planning documents, is your will, which is again that writing that says what happens to your stuff when you pass away. And I note here, and maybe the revocable trust, which we will talk about later. Sometimes you will have a will that pours over your assets to a revocable trust, and the revocable trust contains how your estate is distributed. Number two is a question about who are you naming as your fiduciary. In all of these documents, usually you aren't around to make the decisions. And so a lot of these are appointing someone else to be entrusted with carrying out the terms of the document, and in many cases, standing in your shoes. Again, the fiduciary is the person you appoint to act for you, whether that's after you've passed away or if you're incapacitated. A lot of the times that would be your spouse, your family members, or your friends. We'll note that for many of these roles and most of these roles, they are a lot of work, both emotionally and actually from an accounting perspective, for record keeping. Usually we'd recommend that you name someone who is responsible and responsible with money. And individuals who serve as a fiduciary for you, whether the personal representative or the agent, they are allowed to basically collect reasonable compensation, which can be set by the terms of the document. As an alternative to appointing an individual, you could, well, hire a professional fiduciary, or you could appoint a company that acts as an agent or as a trustee. The pro of that is that they're generally very experienced. You're not putting a family member or friend through, I guess, the stress of acting in that regard. And a professional maintains liability insurance. The cons is that that is more expensive. They're subject to the schedule of fees that they would have. And then there's a little less flexibility because the professional would administer either your assets or your estate subject to their policies and procedures. If you're interested in exploring a professional fiduciary, there's a number of companies that provide those services, though I'd recommend you talk to your estate planning attorney, financial advisor, or CPA, as they may have worked with certain companies in the past that they could refer you to. I didn't really know where to put this slide, so it's here. But another thing to know is that Washington is a community property state. What that means is that assets that are held or assets that are acquired by a married couple is considered community property, meaning that each spouse has a 1/2 interest in 100% of all of their community property. That includes wages and income. That includes the income and wages that are placed into a retirement account. If it's acquired during marriage, unless there's a prenuptial or postnuptial or another property agreement, then it will probably be considered community property. The other side is separate property. Separate property is that property that a spouse owns before marriage. It's also property that a spouse would receive as a gift or an inheritance even during marriage. Separate property can maintain its status as separate property even during marriage, as long as there's a clear intention that it is separate property. It's held in a separate account. It's not mixed in with other community property. And this is important for estate planning because when you die, your will, what you're dealing with, would be all of your separate property. And then if you're married, it would be 1/2 of your community property. The next item for Washington is the will versus the revocable trust. And this comes from that in Washington, you can have a will that disposes of all your assets. A will that disposes of all your assets when you pass away. And a will is a written document that provides that information. The process of creating a will, and Brian mentioned this, is specific. So I do recommend to execute and create your last will and testament, that you speak with an estate planning attorney to make sure that your will follows all the Washington laws, such that when you pass away, there isn't a question that it's your last will and testament. The will, once you execute it, is only effective as far as the personal representative carrying out the terms of that will after it's admitted to probate. In Washington, the probate process is simplified, and this is compared to other states like California or Oregon, because in Washington, a personal representative, when they go to court and ask the court to probate the will, can ask for what are called non-intervention powers. And that is quite a term. Non-intervention powers means that the personal representative can administer the estate without the court intervening. The court would be intervening to approve the sale of property, to approve distributions, and to approve when the estate can be closed. A personal representative serving with non-intervention powers can do that without court approval. And that basically reduces the amount of times that you need to talk to your attorney to go to court and then bill you for that amount. So in Washington, the process is relatively streamlined. On the other side, your will could just say, I leave everything to my revocable trust. And that is the revocable trust plan. In a revocable trust plan, you would have your will, which says everything goes to my trust. And then your trust would include all of the terms that would have been in a will. So what happens to your estate? The will and revocable trust can be used to what's called avoid probate, meaning you don't have to go through the probate process. But that only happens if if all of your assets are in the name of the trust. Because when you die, we're only thinking about those assets that are in your name that don't otherwise have a beneficiary designation, because then they're subject to the terms of that trust. I guess the difficulty here is that a lot of the times you would do this and you'd say, I'm going to put all my stuff in the trust. But then the next couple of years, maybe you buy a new house or maybe you open a new bank account and you don't put that in the name of the trust. So you did all this work to make this will and this revocable trust to put everything in the trust. But then when you pass away, there are still assets outside the name of the trust and you still have to go back to probate. But we're going to talk more on that later. One of the other benefits of the trust is that your will gets filed with the court, but all your will would say is that everything goes to my trust and the actual terms are in the trust. The trust never becomes a public document, and so there's a certain level of privacy that some people would want to have. Trust is also useful if you have property outside the state of Washington. For instance, if you were to pass away and you have a house in Washington and you have a house in Arizona, and you own those in your name, you go to court and the court signs an order saying this is your last will and your personal representative is authorized to transfer your assets in Washington. Your personal representative would have trouble transferring your house in Arizona. They would probably need to go open a probate in Arizona. If instead your Arizona property is held in the name of the trust, you can avoid having that probate in Arizona since the house is subject to the terms of the trust and not subject to the terms of an Arizona probate court. Going to the next slide. We mentioned this before, is that there are assets that are subject to probate, and then there are assets that are not subject to probate, the non-probate assets. Maybe the simplest way to think about this is that those assets that are held in your individual name, when you pass away, a financial institution or the recorder's office is going to be skeptical if someone approaches them and says, this person is dead, transfer this asset because they passed away. Instead, what the recorder's office or financial institution will be looking for is they'll be looking for a court order that says this person had a final will that appointed the personal representative, and this is where the assets are being distributed to. The assets that are subject to probate are then controlled by your will. And that means that the only way to distribute those assets is to go through the probate court process. Now, if your estate is under or is $100,000 or less and doesn't have any real property, there is also a route for what's called a small estate affidavit that doesn't require the entire probate process. But that's in that circumstance. But generally, a probate asset would require a probate. The examples of this would be personal property, real estate, financial accounts that don't have a beneficiary designation, and business interests that are held in your individual name. Now, on the other side of probate, there is the non-probate assets. And a non-probate asset does not need to go through probate. The reason is because that asset has direction either within the agreement or the document that controls that asset. For instance, life insurance, retirement accounts, and 401ks generally have a beneficiary designation where you designate either an individual or a charity as the beneficiary of that account, such that when you pass away, that beneficiary would usually present a death certificate, and then the institution would pay out that account based on that beneficiary designation. Another example of this is owning property as joint tenants with right of survivorship. This could be for real property or for bank accounts. But instead of going through probate, that account, when one of the joint tenants dies, because the account agreement is then owned by the surviving joint tenant. Similarly, there's transfer on death deeds and transfer on death accounts. Again, subject to that deed or that account, it's not subject to probate. Lastly, and as we mentioned, assets that are held in trust are not probate assets because they're subject to the trust, meaning that you don't have to go through the probate process. Now, in all of this, whether your estate is all probate assets or non-probate assets, there would still be the administration of retitling things after you've passed away. So as we kind of talk about that, there are a number of ways to avoid probate. Now, do you need to avoid probate? Not really in Washington, as it's not as, I guess, expensive as in other states, but it is something that some people find valuable, or maybe they've had an experience with a family member's estate or trust where they really would like to avoid probate. One way to do that is to make sure that all of your assets are non-probate assets. Now, the caveat here is that avoiding probate does not mean you're avoiding administering those assets, and it doesn't mean you're avoiding any tax on those assets. Your non-probate assets and probate assets are all included in your estate for estate taxes, which we're going to discuss at the end. And it doesn't, and also, I guess there would be your final income tax return, and it doesn't do away with the responsibility of the personal representative, or if there's no personal representative, those people, your fiduciaries that are in charge of your estate for settling and paying your taxes. In this list, we kind of mentioned a few of these, but ways to avoid probate are making sure that all of your beneficiary designations are updated. That means that you want your beneficiary just to be designated as individuals or charities. A lot of the times, if a beneficiary designation is not made, the defaults usually could be a spouse or children, but it could also be to your estate, which would actually mean that even though there's a beneficiary designation, it's payable to your estate, thus requiring probate. You could also have most of your assets as payable on death or transfer on death. One of the consequence, though, of that is that when you pass away, those assets are transferred to that person, to the survivor. That means, though, that there might not be basically an amount of money that could be used to pay CPA or attorney's fees related to the administration of other assets of your estate. One way to avoid probate is the fully funded revocable trust, which means that you prepare a will, you prepare a trust, and you fully fund that trust, which means you retitle all of your assets into the name of the trust. Spouses can also have a community property agreement. And what that would do is that provides that all of your property is community property. And when you pass away, all of your community property vests or is distributed to your surviving spouse. That would avoid probate at the death of the first spouse. But at the death of the second spouse, a probate would probably be necessary. Again, there's this small state affidavit for estates that are $100,000 or less. Number 7 is what happens if you die without a will. Without the will, your estate is subject to intestate succession laws. That means that your estate, there's a body of Washington law, RCW 11, that provides for what happens to estates when there is not a will that provides what happens otherwise. That means that under intestate succession, there is a priority list of who can be appointed as the administrator. The administrator is the personal representative when there's no will. It goes through a very similar probate process. There's just no will. But because there's no will, that means the order of who can be appointed, and it's usually spouse, children, and then other family members. The person has to be within that priority. There's some notice provisions that may have to be followed. It also raises questions about whether the administrator can be appointed without court intervention, meaning that the administrator would have to provide to the court that they should be granted those non-intervention powers. The administrator would also have to say that they should act as the administrator without a probate bond. A probate bond is essentially an insurance policy that the administrator would provide that, if they were to flee the country with the assets of the estate, the bond is there to reimburse the heirs. Usually in a will would provide that the personal representative would act with non-intervention powers and without bond, but subject to state law, there's a question there. Under state law, the distribution of the estate is also set under the law of descent and distribution, which is what determines your intestate heirs. Those are your heirs at law. That's who can inherit your property. The rules, the rules are that, the spouse would receive 1/2 of the community property, and then a portion of the separate property if there are surviving if there are surviving children. If there's not a surviving spouse and there's no surviving children, the intestate succession laws look backwards. They look to parents. They look to the issue of parents. Really, there's an analysis of who would be receiving the estate. It's important. One of the reasons it's important, particularly to have a will, is if you have minor or incapacitated children. Because in a will, you can provide that for your minor or incapacitated children, that provisions can be made for how assets would be distributed to them. And also you can designate who you would wish to be appointed as their guardian or conservator. Now, there would still need to be a guardian or conservator process to who would be their guardian or conservator. But I guess as far as the distribution of assets, if you don't have a will that provides for that, that would mean that usually your administrator would need to ask the court for the best way to make a distribution of assets to a child. Again, this is kind of a cost savings analysis of spending money now to have the will to provide for that avoids possibly spending a lot more money later on either attorney's fees related to having to figure out what's happening to money for your minor children. An estate plan is also important if you want to provide for your pets. Pets, I don't like saying it, but they are considered tangible personal property. And you can designate who gets your pet, but it might also be helpful to provide an amount of money for the care and maintenance of your pet. And this is something that I think is important to do, or at least to say where you would want your pet to go. Otherwise, the administrator, who might not know that you have pets or know where you would want your pets to go, would have to spend time figuring that out. So who gets your estate? So we talked about what happens if you don't have a will, and who gets that estate, and that goes to your heirs, the family members. So it could be important for you to have a will that provides where you want things to go. And that could be individuals. That could be trusts that are set up for individuals. So a trust for your spouse, a trust for your children. You could also always designate the Seattle Public Library Foundation or any other charitable organization that you choose as a beneficiary of your estate. Again, if you don't designate that in your will or your trust agreement, under intestate laws, though, you may have spent all of your life planning on that your estate would go to the charitable organizations that you've supported. If you don't have that in the document, there's not an avenue for the administrator to say that they passed away, but the heirs shouldn't get it, instead should go to a charity. So if you have any charitable intentions, it's important to get that in your estate planning. Now, leaving money or assets to a charity can reduce the size of your estate and possibly reduce estate taxes, given that donations to charity is basically a deduction from the total value of your estate. There's a number of different ways to give to charity. There's just a bequest in the will of I want to give X amount to the charity of your choice. You could also name a charity as the beneficiary of one of your non-probate assets of a retirement account or investment account. There's also something called a donor advised fund, which is an investment account that you would set up now, or you would direct your personal representative or trustee to set up, that would be funded with an amount of money. And the investment advisor of that account would use that account to provide for the charities that maybe you supported during your lifetime. Number 9 is that Washington has an estate tax. And now estate tax, and this is a large part of my practice or the planning around estate tax. The estate tax is a tax that is assessed on the value of your estate on the date that you passed away. And so what that looks at is that looks at a snapshot of all your stuff on the date you passed away. And based on the size of that, and then the exemptions and deductions we're going to talk about, is if there is a tax paid. Now, there's a federal estate tax. That's the federal level. And the exemption amount for that is $13,990,000. That means that if your estate exceeds that amount, a federal estate tax return at your death is required, and taxes paid 9 months after you pass away. The tax rate is subject to the amount, is a bracket tax based on the amount of over the exemption, and it ranges from 18 to 40% of the taxable amount. Now, when we talk about estate taxes, one thing we're going to talk about is the unlimited marital deduction, meaning that assets that you leave to your spouse are deducted from your total estate, meaning that if you leave all of your assets to your spouse, they are included in the unlimited marital deduction, and there would not be any estate tax payable on your death. One of the reasons why that's important is that the federal exemption is portable, meaning that at the death of the first spouse, though all the assets went to the surviving spouse and there's no estate tax paid, that surviving spouse can file a federal estate tax return, and portability, they can transfer the exemption amount, meaning that when the survivor then passes away, they have an exemption of $27.98 million to use for their estate. Now, for the federal estate tax, that exemption is set to sunset, which means it'll go back to previous law prior to this exemption, this $13.99 million amount. And it's estimated that for inflation, that would go back to about 5 to 6 million. And that'll be in 2026, so next year. So that's if Congress doesn't do anything, that is what happens. So that's all at the federal level. And now if we move to the Washington level, Washington has an estate tax. The Washington estate tax exemption is this $2,193,000. And what that is that's 2 million adjusted for inflation. However, that $2 million number for a number of years was based on an inflation index that no longer exists. But recently, our friend Bob signed a bill that sets to increase the Washington exemption to $3 million per person after July 1st, 2025. So next month. What that means is that the exemption amount in Washington increases to 3 million, meaning that in Washington, if your estate is under $3 million, No Washington estate tax return is required and no estate tax is payable. However, if your estate exceeds that exemption amount and without deductions, again, if you didn't leave everything to charity, the tax rate starts at 10% on the first million and then up to 35% over the 9 million. This new bill increased the brackets such that there's a higher percentage at the higher end of the states. Now, different than the federal exemption, the Washington exemption is not portable. What that means is that if the Washington exemption amount is not used, it's lost. For a married couple, what that means is that if the entire estate goes to the surviving spouse outright, then the exemption is not used. And then that means when the surviving spouse passes away, their exemption amount is whatever the Washington amount is at the time of their death. It would be $3 million. This is really probably the crux of Washington estate planning. And if you have questions about kind of estate tax planning or how to minimize Washington estate tax and take advantage of the Washington exemption at your death through the use of marital trusts, that's something that you want to talk to an estate planning attorney about. And that's something where you would be both talking about the preservation of your estate tax exemptions, but also the step up in basis of all your property as of your date of death. Here's number 10. Washington, though we have an estate tax, there's no gift or inheritance tax. An inheritance tax would be a tax that would be against those who receive property from an estate. And a gift tax is a tax based on gifts that you make during your life. In Washington, because there's no gift tax, gifting is a way to reduce the size of your estate. Because by making a gift, by giving your property away, you reduce the size such that when you pass away, your estate is that much less. The recipient of a gift does not pay any tax on the receipt of property. The gift tax only comes into play because there is a federal gift tax. And the federal gift tax means that taxable gifts you make eat away that 13.99 million, your unified lifetime credit. Well, what is a taxable gift? Well, taxable gift means it's a gift over the annual gift exclusion. The annual gift exclusion for 2025 is $19,000 per person. That means that you can give $19,000 to anyone you like. And as long as it's $19,000 or less, then there's no gift tax return, a federal gift tax return to reduce your lifetime exemption. Spouses can each have their own exemption amount such that the spouses could give $38,000 per person and not have to eat away at their lifetime exemption amount. In any case, by engaging in gifting, whether over a long period of time or maybe doing more significant gifting, you can reduce the value of your estate. But the alternative is that once you make a gift, that property is no longer yours. That property is whoever is the recipient of that gift. So it takes careful planning to both make sure that you have enough stuff to provide for yourself and balancing, I guess, estate taxes on the other end. Another way to make gifts is through what's called a UTMA account. Generally, it's the Uniform Transfer to Minors Act. And it's an account that would be made for the benefit of a minor, and provided that the account is funded and it is held for the benefit of the minor, that could be considered a completed gift. In any case, if you plan to make gifts for the purpose of minimizing estate tax, you should do that with the advice of an estate planning attorney or a CPA. The last slide I have is these are some resources for either pro bono, which means that it would be legal clinics without being represented by an attorney, and other information on estate planning. Again, I will provide these slides so that you don't need to write these down right now. You can again look at them and go to these URLs for any information that you need on this. Though for a lot of these questions, you can look online or you can contact a local estate planning attorney who would be hopefully happy to answer these things for you. And I've set some time for some questions, so I'm going to look through these and I'm going to see which ones have upvotes. Okay, so I have the first question is can we create a CRUT with an SPL that invests 100% in equities so that the annual distributions amount are taxed advantageously? Which is a great question for your financial advisor. A CRUT is an acronym for a kind of trust. And an SPL, I believe what we're talking about is that's an alternative investment piece. I think what this question highlights is that there are a lot of different estate planning tools that either estate planning attorneys or financial advisors can use that are advantageous to their clients. But without having the counsel of either an attorney or a financial advisor and knowing the full extent of your estate and your intentions, without having that particularized advice, it's hard to answer those. The next question is, if you've invoked your power of attorney while you're still alive, can that person change the beneficiaries on your accounts? If so, is there a way to protect your intentions? So that's a good question. So a power of attorney, can be drafted so that it is effective immediately, meaning that when the principal signs that, you have said, my agent can stand in my shoes and they can do whatever I could do. Now, an agent may be under the power of attorney. They may be able to sign beneficiary designations that change beneficiaries. However, an agent cannot change your will, which means they can't change the distribution of your estate. One thing that I would say is that your power of attorney can be drafted or tailored to whatever you want your agent to be able to do. The power of attorney has all of the powers. If you have, I guess, questions, you look to the power of attorney document, and presuming that you still have the capacity to do so, you can revoke or amend your power of attorney at any time. I'm just looking here. The next question was, does Washington have an unlimited marital deduction? And yes, the Washington law follows the federal law. So yes, there's a unlimited marital deduction, meaning that in Washington, if you pass away and your will provides that your entire estate goes to your spouse, or your entire estate goes to certain trusts for the benefit, the lifetime benefit of your spouse, subject to specific terms, those could be included in the marital deduction, meaning that no estate tax would be paid. I'm just looking at these other questions. Oh, I had can the fiduciary you name make the decision to hire someone to help them if needed? So a lot of the times, your fiduciary is usually authorized to hire help. What that would mean is that the fiduciary, the personal representative of your estate, would usually be authorized to hire an attorney to assist them, maybe with the probate practice, maybe the probate process, maybe with the administration of the trust under the will. They would be able to hire a CPA or an accountant to prepare income tax returns or estate tax returns. Although the fiduciary is on the hook, so to speak, they would have the power to delegate that authority to other professionals, because typically the administration of an estate takes a lot of different people. This is a longer question I'm going to try to read. So the question is for a solo ager, and I think what that means is that an individual who would be appointing a professional in a number of these different roles. And would it be better to divide those roles up between different companies? And I think that's actually not all companies perform all the roles. Not all companies would act as your healthcare power of attorney. It depends on what the company does. So first, you need to contact the company and confirm what roles would you be able to perform. I think that there's certainly some convenience in if it's just one company that will do it all, that's probably the best way to do that, because then you wouldn't run into, I don't know, differences between company policies for how things should be administered, and record keeping would probably be more seamless. I think that probably the most important thing is that you feel comfortable with the company that you're designating or the fiduciary that you're designating. Because presumably for most of these, you won't be there to make calls. There's questions about costs of these things. So I guess I would start off at the very baseline of things is that there are documents out there and things you can buy probably for as little as $500 that could be the do it at home will or trust document. Now you would be preparing those without the advice of an attorney, and the instructions may not be the instructions for Washington specific. And one of the pieces of my job is reviewing documents like that and helping families trying to figure out if these are valid documents that can be used. So that's at one end of the cost scale. Then if you move into hiring an attorney to do something, the attorney's based usually as at an hourly rate in kind of the King County area for estate planning. That could be anywhere from $250 to $600 an hour to prepare estate planning documents. And depending on if that includes estate tax planning and kind of other planning. So not just saying who's going to be in charge and where things are going, but also planning about is there going to be estate tax paid? How is it going to be paid? Where are those funds going to come from? I would say that kind of ranges anywhere from probably the final fee of $1,000 to upwards of $6,000. Oh, that's a good question. Does a fiduciary have to live in Washington State? If not, would they be required to travel to Washington? So this one raises a few issues. There's both practical and real. From a practical perspective, a lot of the times the fiduciary, if they are working with your local bank or they are managing your bills, maybe they could do that remotely. Maybe they don't need to be in the state of Washington. If they are your fiduciary for healthcare decisions, and usually that involves assisting the principal with medical appointments and scheduling things, it might not make sense to have your healthcare agent far away or in a different time zone. From a, I guess, more real or financial perspective is that certain roles are just harder to do outside of the state where the principal is living. Now, and also, I guess the other thing is if a financial institution or a hospital has a question, and the only person that can answer that question is outside the state of Washington, that may raise red flags for them, whether those are right or wrong, which may involve kind of a headache for your agent. The question is, so how do I get started? What materials do I need to put together before consulting an estate attorney? Well, the estate attorney will probably tell you. Before you meet with your estate planning attorney, their first question is they are going to ask you your name and your family members, because they're going to run a conflicts check to make sure that they don't represent any adverse parties. But then after that, what they'll probably ask is, where do you want your stuff to go? But also, what is your stuff? They're going to ask about the different assets you have and probably the value of those assets, because that total amount is going to change the advice that they provide, whether that's in terms of estate tax planning, or if you have a number of specific gifts, meaning I leave 15,000 to Tom, George, and Barbara. Is there that amount of money that will be able to provide and satisfy all those gifts, or is there a better way to make that gift for all of them? I guess, sorry, the answer to the question is usually if you can summarize or think about all the stuff you have, and then I guess if you can start thinking about where you would want that to go, and then also importantly, who you would want to make those decisions for you, whether you're incapacitated or you've passed away, who's going to be in charge of all that? The next question, does non-intervention powers have to be written into the will? If it's written in the will, that's the easiest way that the court will grant it, because the court will say, it says in the will that there's supposed to be non-intervention powers. And so when the will goes through probate, the judge will sign the order because it says so in the will. If it's not in the will, but the will designates the surviving spouse as the personal representative, the court will likely grant non-intervention powers without it being in the will. If it's not either the surviving spouse or it's not in the will, the court will determine whether the estate is solvent, meaning that the assets of the estate exceed the debts, and that it's in the best interest of all the beneficiaries to grant non-intervention powers. Usually that requires notice to the beneficiaries, because they would be the ones who would object and say, I don't think it's the best idea for this person to not have any intervention of the court. Or maybe everyone would agree and just sign a document saying, we would be happy if they were the personal representative, they had non-intervention powers, and we didn't have to pay any more administrative fees for attending a court hearing or anything like that. This question is actually another question, is if you have your estate set up, your estate planning documents set up in Washington and move, presumably outside the state of Washington, do you need to have your things redone? Generally, I recommend that if you do move to another state, that you would have your estate planning documents redone, or at least looked at it by an estate planning attorney in that state. Like I said, the probate process, wills, powers of attorney are all subject to state law, and they're specific. Now, states have similar laws on this, but there could be differences. The issue could be that if you're in another state and maybe on this one point, there is a difference between those two laws, and all your documents say all my stuff is governed under Washington law, but I live somewhere else, there could be a question which creates probably a headache for not just the person, your fiduciary in charge, but also that attorney. I guess the opposite is that if you lived in another state and you moved to Washington, why would it be important to have an attorney look at your stuff? Well, for what I just mentioned is the difference in laws. Also, another reason is that Washington has an estate tax. Depending on the state that you moved from, they may have a different estate tax, a different exemption amount. Your documents may provide for estate tax planning that works in one state, but maybe doesn't make sense in Washington. I think redoing estate planning or looking at estate planning when you move is an important thing to do. I'm just looking for upvoted questions. We have a question of, is it possible for an individual to set up two revocable trusts with different assets? So we talk about trusts and that you can set up a trust. So you can set up a trust that manages your estate when you pass away, and all the assets that are in that trust or under your will are sent to that trust when you die, are subject to that trust. You can have another trust that does something else. Each of your trusts presumably has a separate name and can hold different assets. Now, each time you create a trust or you fund a trust or have anything at all with trust in the word, that increases complexity. That increases complexity for the trustee managing that, and also any other fiduciary that has to manage your assets or the distribution of your assets. There's a question here about, do people that inherit get a step up in basis? This is another tax issue. Basis is in regards to income taxes, capital gains. When you pass away, the assets that you own step up in basis to the date that you passed away. That means that the basis that you initially bought for which if you sold it during your lifetime, capital gains would be calculated based on the difference between the sale price of the asset and the basis that you acquired it for. When you pass away, that basis steps up to the value that you passed away. For investment accounts, for instance, you can determine the value by using investment software to determine the value of a certain security on a certain date, your date of death, which could become the basis. The individual that receives that asset, if they receive the security in kind, would receive it at that basis. The same is true for real property. Real property steps up in basis to the date of death. The entire basis steps up. So husband and wife own a home. Husband passes away. The basis is then stepped up to the husband's date of death. Later, when the wife passes away and they still own the home, there will be another basis step up for the entire value of the property. What that can provide is that individuals that inherit that property, they essentially inherit it at a high basis, meaning that if they sell the property, the capital gains would be limited. Now, it's an important balance here because by saving that income tax or that capital gains tax, you may be increasing estate tax that would be payable. So it's balancing these taxes is an important reason why when you're doing estate planning, there are a number of different tax concerns, which means that you may be seeking advice from an attorney, but then also an accountant or a CPA.
All right. Well, Mitch, you've given us a tremendous amount of information to process. I know on my side, I've got a whole page of notes here to go through. So huge thank you to you for offering us the gift of your time to share information and ideas with all of us today. I hope you've found it incredibly valuable. I hope all of you listening have found it valuable. And again, Mitch is with Stokes Lawrence, and you'll receive a copy of his slides as well as his contact information for today's call via email very soon. And I loved the question that I think it was Allison posted about how do you get started? And from my own personal experience, helping my mom with her estate, one of the things I would say is just pick up the phone and give a lawyer a call. Somebody like Mitch or some of the estate planning attorneys we worked with over the years, usually they're pretty happy to have an introductory call with you to hear a little bit more about what you're looking for. And it's a good opportunity for you also to see if an attorney is a good fit for you. So my advice personally is just to kind of pick up the phone and make a call or send an email and learn from each individual attorney about what their process is going forward. So thanks, Mitch. Appreciate you being here. And before we go, I just want to do a couple reminders. As you exit this webinar, thanks, Mitch. Take care. As you exit this webinar, you'll be prompted to take a quick survey. Some of you had specific questions about like the CRTs, but if it wasn't answered or whatnot, feel free to drop that into your survey form, and we can connect you with some of the resources to get your questions answered. And as you think about your own legacy planning, please remember that a charitable bequest to your library is one of the most meaningful ways that you can support nonprofits that you love. Libraries are what I'm sure one of those. But if you have questions about estate planning and how it pertains to the library, please reach out. Both Jessica and my contact information will be on the closing slide. We always love talking about planning for the future, and we'd be happy to continue the conversation offline. And again, let us know if you do include the library in your estate plans, because we want to be able to make sure that we recognize and show you the impact that we're having over the course of your lifetime, so you can enjoy hearing about what we're up to. And lastly, I want to say it is summertime, which means summer is a great time for book bingo. And this year, Seattle and King County, we are jointly presenting book bingo along with our good friends at Seattle Arts and Lectures. So I encourage you to go online or stop by a local branch of either King County or Seattle and pick up your bingo card. And I really do hope you have a great summer and enjoy lots of happy reading. And thank you for joining us today, and have a wonderful afternoon. Take care, everyone.